Okay, guys, welcome back to another episode of Lawyered Up. My name is Jared Moore, and Lawyered Up is the program where we explore Native American legal issues. Most of the time it's court cases, but in this instance we're going to be talking about something that affects basically every Native American that's going to try to get any federal services. Just to let you guys know, today was the oral arguments in SC 2024-05 in the matter of the constitutionality of NCA 24-077. Those are the oral arguments that yesterday in the live wire I was telling you guys I didn't think they were going to have because of the weather. Well, they had them. So, and if you guys remember from prior coverage, the video is only going to be up on the MCN Supreme Court's Facebook page until the end of the workday today. So if you want to see it, you need to go right now, leave my stream, and go to their Facebook page. There's a link in the description of this video. You can click it. You can go watch it. It's about an hour and a half long. I am going to have a written synopsis or summarization of the oral arguments that's going to be posted on Mvskoke Media's website next week. I can't guarantee which day because I've got to go back through my notes and write it. So if you want to go ahead and watch the oral arguments live, or not live, it's a recording. But click that link and bounce out. We'll be here when you guys get back. The other thing I wanted to mention is you guys saw yesterday I was doing a live wire from my house, and I came into the studio today, and that's why I have this boo-boo here, is because I slipped and hit my face on ice. So this is not from a fight or anything. This is just from getting into the studio today. I just wanted, in case it came up in the chat asking me why, I've got a gash in my face. That's why. So, with all of that being said, today's guest is Paul Spruhan. He is visiting assistant professor at the University of New Mexico School of Law, and he is also the author of CDIB, The Role of Certificate of Degree of Indian Blood in Defining Native American Legal Identity, which was published in the American Indian Law Journal, Volume 6, Issue 2, and at the time that he published that article, he was with the Navajo Nation Department of Justice. So, Mr. Spruhan, thank you very much for joining me today.
Thank you. Happy to be here.
So, it's going to take us a while to get through all the information. So, I wanted to just go ahead and jump right in and start off with, could you give us the history of the CDIB? Well, first off, let's talk about what is a CDIB? What is it for?
Sure. So CDIB is shorthand for Certificate of Degree of Indian or Alaska Native Blood. That is its official name, according to the Bureau of Indian Affairs. When you look it up on the BIA website, you will find an application. The latest version expired at the end of January, but it is still an application that one files. It is a federal document, though sometimes it is conflated with a tribal enrollment document. Some tribes issue one document which serves the purpose of tribal enrollment, but also probably because they're funded through a 638 contract or compact with the BIA, they are also issuing the federal document. So, this term is sort of used loosely sometimes in discussions, and it seems to mean tribal enrollment sometimes, or it's the actual precise CDIB. So when I use it for purposes of this article, it is the specific, precise federal document. And, it depends, it varies on region, but say the Navajo Nation, it has one, it says so-and-so is, certified to be on the roll of the Navajo Indians and has such and such blood quantum certified official. And in the Navajo Nation's case, since they do operate pursuant to a 638 contract, it's a tribal official, though some tribes utilize the BIA directly, and the BIA is still issuing them, so it will be signed or certified by a bureau official as opposed to a tribal official.
Okay. And you guys out there, why would you want a CDIB? Well, you have to have a CDIB if you're going to participate in any federal programs. If you're going to get a loan for Native Americans for housing or anything like that, IHS and all those things, you got to have a CDIB. Is that fair to say, Mr. Spruhan?
Yeah, I would say that. I mean, it's interesting because when you read the BIA's sort of version of why a CDIB exists and what it's for, they'll give you a very finite list of statutes and regulations. And those are ones that don't say tribal member regardless of blood quantum. It'll say 1/4 Indian blood, 1/2 Indian blood. Certain statutes are hybrid, like the Indian Reorganization Act, for instance, defines Indian as tribal member, descendant of a tribal member on the reservation, and all other Indians of 1/2 or more Indian blood. So you can fulfill that criteria in one or more of those ways. But in Alaska, interestingly enough, there's a whole different construct up there, of course, because they have Alaska Native Corporations, Alaska Native Claims Settlement Act. So there are certain statutes, ANCSA, the Alaska Native Claims Settlement Act, and then the Marine Mammal Protection Act's regulations define eligibility for hunting and other things using blood quantum as well. So they have a slightly different reason why they use CDIBs up there, but nonetheless, it is a necessary document because their eligibility is defined purely by blood. So you have to be 1/4 Indian or Alaska Native to be able to be eligible for some of these programs.
I see. So with that being said, let's talk about the history of CDIB and just bring us up to, the modern where we're at right now.
Sure. And as the article discusses, and nothing has changed since 2018 on this point.
And I should mention to you guys too, if you want to read the article, there's a link in the description of the video. I highly recommend it. It goes through and talks in detail about what we're going to be talking about too. So I'm sorry, Mr. Spruhan, go ahead.
Oh yeah, sure. No problem at all. And it's mysterious. And I talk about it being pervasive in Indian country, but mysterious because there's no paper trail, or at least there's not a direct paper trail. And this is fairly common with the Bureau of Indian Affairs over the years. I'm sure this should not surprise many of your listeners that the BIA has done a lot of stuff over the years under the table, which is to say not through published regulations. So if you go to a law library, if you still pull out physical books, you can pull out 25 USC, the United States Code, or you can pull out 25 CFR. Neither one of them have any real criteria as to how the BIA issues CDIBs, what rules apply, et cetera, et cetera. So it's just a matter of practice. There's sort of mysterious regulations that if you sort of comb through the catacombs of the BIA's website, at least in 2018, I don't know if they've taken it down since then, there's these regulations that they promulgated in the Bureau of Indian Affairs manual in 1978 or so, but they don't seem to actually apply because no one mentions them. I did just coincidentally, when I was studying blood quantum generally, and this was the last article in a series of articles that I wrote on kind of the legal origins of blood quantum, came across a document, and it was a mysterious document. It was one of these memos, and if you've ever done federal government archival research, you get folders of random memos from one federal official to another, and sometimes they have dates, sometimes they don't, sometimes they're signed, sometimes they're not. So this document is just called something to the effect of criteria for Indians for educational loans. No date, no signature. But what it says is, hey, we need a way to figure out who's eligible and who's not. This is whoever the author was. My suggestion, do a certificate issued by the BIA, probably the local BIA agent at the time, certifying the amount of blood and that the person is on a tribal roll. So it seems, and no one since 2018, it's been almost 7 years since this paper came out, has produced any additional evidence of the origins. And some people have done FOIA requests, and still nothing has materialized other than this document. There is a memo issued about 1963, and it's talked about one of the footnotes of the article, that some people point and say this is where it comes from. It talks about certain aspects of how the BIA does these things. The paternity rule, which we may talk about, which is a very important aspect, of course, of the CDIB program, and it sort of says this is how we're going to calculate Indian blood. It doesn't say these are regulations to determine how we're going to do CDIBs, but
right.
It's a fascinating publication from 1984 from the Phoenix area office called Tribal Enrollment, and it's a training manual that the BIA issued to tribal enrollment offices in the Southwest. And it talked about how to use blood quantum base rolls, this and that. But as an appendix, they included this, and I think it's 1963, I may have my dates wrong, memo from, some rando BIA official. And so when you put it all together, there's this mysterious document in the archives without a particular date that seems maybe 1940. Then you have this 1963 memo. Then you have these mysterious regulations that seem to be after 1978 because it mentions the Indian Child Welfare Act. And that's it. That's all you're going to find as other than the application, right? So there's an application with instructions as federal forms, tend to do, but you won't find regulations. You won't find guidance. You won't find actual binding guidelines that the BIA follows. Instead, it just follows them. It just applies these rules.
Right.
So to say, what is the history of the CDIB? It just almost like it appeared, it came out of the ground and just, sort of mysteriously came to be, which is sort of odd for such a document of immense importance. But there you have it.
Yeah, it's kind of mind-blowing, and I see your questions popping up in the chat there, Mvskoke History. We're going to get to those questions after we get through the history section. I did want to reiterate to the audience kind of what we're talking about here, and correct me if I say anything that's wrong. But the impression of the story that I got from the article is that, Congress, that the CDIB has never been codified by Congress.
That's right.
Congress passed some laws that said Native Americans can get housing loans and things like that, and they told the BIA, hey, you guys, figure out how to do this. And then these letters that you were talking about, where the guy's like, how do I do this? And they're like, well, just write him a letter, write him a letter of recommendation. And so there's no. Which to me, I was reading that part and it was really kind of scary to me because I was like, the CDIB is one of those foundational documents as a Native American that you get hopefully when you're young or at the point that you start becoming engaged with the governmental processes in your tribe or the federal government. And to know that there's like not any codified hard and fast rules about how it works is not good, like in my opinion, I'll say that. But let's flash forward to in the 80s, there is a Chickasaw citizen who goes, and correct me if I'm telling the story wrong, but he goes to an IHS clinic and they tell him that he can get a new CDIB card that's smaller. It's not like a big letter, and it's laminated if he just applies for it. Could you tell the story of what happened from there?
Yeah. So this is the Underwood case, right? So this is 1986. And so it seems that's the story. I mean, the opinions will tell the facts as presented or as they see them. So, I'm sure there's a backstory, but at least according to the Interior Board of Indian Appeals, which is the administrative tribunal of the Department of Interior that heard this case. Yeah, and they said, oh, wait a minute, we've got a little problem here. We've done a review of your blood quantum, and it turns out you did not, if I'm recalling the details correctly, provide proof of paternity of your father. Therefore, we're going to cut your blood quantum in half when we give you the new laminated card.
Right.
And Mr. Underwood was understandably upset about this and challenged this. And as the opinion, you can find it online. It's fascinating stuff. You read it. And I quote or cite the arguments made on behalf of Department of Interior. Oh, well, we issues this as a matter of discretion. It doesn't really mean anything. It's not binding on anybody. So you can't review it, IBIA, right? And IBIA, and I always say to my class, was the judge amused by the arguments of the attorney when a judge talks about the exact argument made by the party? You're in trouble, and that's what they did here. They said, isn't it interesting that the federal government argues this, and basically, I mean, you just can't make this stuff up. It says not even BIA employees are aware of some of these documents that you're talking about that is supposedly how this program runs, right? Because they mentioned some random 1977 document, don't cite to it what this is, and some other guidance or this or that, the other. And I'm trying to remember, there's that great phrase, the rules only known to an initiated few, I think is what right. Right. And the initiated few are the only ones who know how CDIBs work. So essentially they were saying look, to have binding rules to be able to apply to this guy, like if you don't show adequate proof of paternity, we're going to cut your blood quantum in half, which we can talk about still exists today. That's still a rule that
Right.
BIA applies, right? You need to go through notice and comment. And when you see regulations in the Code of Federal Regulations in Title 25, there's a process. And you can, as you mentioned, track it in the Federal Register. They say, here's a proposed rule. This is what we're thinking about doing. Please provide your comments. And then when it issues the final rule, we say, we didn't listen to you, but here's this comment, that comment, that comment, that comment. No, we're not going to do that. And so that's how you're supposed to do things. But as the IBIA points out, this is not how the BIA has traditionally done things on many things. I mean, to the fact that you have to go into the archives to find random memos, directives and with mysterious numbers, right? The directive number 3124, that kind of thing.
Yeah.
Suggest that the BIA is used to just issuing whatever it wants and doing whatever it wants, even if it is supposed to follow the general rules applicable to federal agencies, like doing notice and comment. So
Yes.
the IBIA, as you know, said, sorry, we're not going to let you apply this paternity rule, Mr. Underwood, because you do not have proper regulations. Therefore, tough luck, Interior, or BIA in this case, you can't actually issue this revised blood quantum to Mr. Underwood.
Yeah. And so in a nutshell there, guys, there's some concepts I wanted to kind of touch on. Number one, the Federal Registry, so the federal government publishes all the regulations, so citizens that have to challenge a ruling by the government or apply for different things, so they know what the rules of the game are. It's, you can file this appeal with this organization and it goes to here, and that's how democracy and everything is supposed to work, is we're all supposed to know the rules, what the laws are and everything, and we play through the game, right? And that problem with the BIA is they haven't had to do that, and they haven't been doing it, and so you don't know what the rules are. In this instance, you had a Chickasaw citizen who was just trying to get a new card. They told him they were going to cut his blood quantum in half, and the IBIA, which would be at the time an independent committee, is that correct? They were supposed to be independent from the Department
It's
of
an administrative tribunal within the Department of Interior. So certain types of actions by agencies in the Department of Interior, in this case the BIA, you can appeal those actions, and it essentially functions as the court. It still exists today. So there are certain things, if you want to challenge the acquisition of trust land for a tribe, for instance, you may have to exhaust your administrative remedies, which means filing an appeal of the decision in the Interior Board of Indian Appeals. So when I was working at Navajo DOJ, we had 4 or 5 cases that involved pleading before the IBIA.
Yeah.
Right.
Well, and one of the interesting.
So I mean, that's how it works. So if the government does something through an administrative agency, you, depending on what the regulation says, have the right to appeal to a tribunal. So there's an Interior Board of Land Appeals, there's a Board of Contract Appeals. So it's essentially a court, right? And so this is the court that deals with certain aspects of what the BIA does.
And one of the things I found interesting was that happened, and the IBIA ruled against the BIA and said, no, you got to give him his card back the way that it was. Then the BIA went and they changed the classification for that appeals process to remove the IBIA out of that loop, so that they review the appeals to it, which to me was classic bureaucratic baloney.
And it gets even better on this point.
Go ahead.
It's probably mentioned in a footnote. They did that without notice and comment. The change of the appellate jurisdiction of the IBIA itself was done without providing public notice and comment. And so, Underwood, the IBIA said, you can't apply this rule because you didn't provide notice and comment. They just changed the powers of the IBIA so they couldn't hear any of these CDIB challenges. And when they did that, they buried it in the Federal Register and talk about, well, we don't have to provide notice and comment because this is just a procedural aspect of someone asserting their rights. I mean, again, you just can't make that stuff up.
Sure. And so then there's also this thing that happens at this point in time where tribal citizenship agencies also become able to issue CDIB cards working with the federal government, and it's causing this lack of these regulations and codification is causing them problems with for people. So the 5 civilized tribes in Oklahoma in particular start lobbying Congress and trying to get the BIA to get these regulations finalized in the Federal Register. And if I remember correctly, they were at, I think it was 1999. It had been 20 years or so, and they finally got them put on the Federal Register for public comment. And
Right.
then I had gone and looked and tried to see if those regulations had ever been finalized, and I wasn't able to find any finalization there. So I wanted to ask you, do you know, do we have finalized CDIB regulations on the Federal Register yet?
Yeah, if you can't find them, they don't exist. And they don't exist because they've never been finalized. So they've been pending in theory in draft form for 25 years now, right? Because it was 2000, I think, when they issued the draft regulations. And as I document in here, you'll find dribs and drabs in the Federal Register sort of explaining why they haven't done it. And I think, and I may have to go back and look at this again, but it sort of disappears after 2006. I mean, it basically says, oh yeah, we're waiting for more tribal comment. And then they use some, vague phrase like, for other reasons, we're unable to finalize these regulations. But it is interesting because when you Google, which I did earlier today to prepare for this, there is an obscure process within the Office of Management and Budget under a statute called the Paperwork Reduction Act. And the BIA application for CDIB has an OMB control number at the top, and it has an expiration date at the top. That's because whenever a federal agency collects personal information of an American citizen, they have to justify it to OMB through this office in OMB. The acronym's OIRA. I think it's let's see, what does it stand for? It stands for the Office of Information and Regulatory Affairs. And because all of this is public, there's actually a website, which is not a government website, that tracks each control number. So you can plug in the control number for CDIB and see all the documents that the Bureau of Indian Affairs has submitted to OMB to justify their collection of personal information. And so there is an application by the BIA pending, because it's every 3 years. And there's a statement, there's a form, there's always forms in the federal government. So there's a form they had to fill out to justify this, and talks about the CDIB program. This was submitted just October 17, 2024. And so the BIA is still obviously issuing CIBs, and it is also still justifying why they do so to the Office of Management and Budget. But the regulations just disappear off the face of the earth after about, I think, 2006.
Yeah. So guys, this is the scary part. I'm going to say scary stuff. So, and correct me if I say anything that's incorrect. As far as CDIBs are concerned, since there hasn't been any finalized regulations, the BIA can go in and change the regulations however they want. They can change the rules of the game as far as appealing any decisions they make, or indeed anything. The BIA can go in and review individuals' CDIB documents and determine if they can't find a birth certificate on the paternal side of the family back to certain times, then they can reduce your blood quantum. They can make those types of decisions and you can appeal it, but the ultimate thing is going to come down to the Department of Interior decision.
Yeah. No, that's right. And after the decision is done, because one of the things that I talk about is how the draft regulations seem to think that it's due process after the federal decision, as opposed to saying, hey, we're thinking of doing this. Do you have a problem with it? Would you like to appeal in advance? We're just going to make the change, and then there's a process. And as we said, it's not the IBIA. It goes through essentially the BIA bureaucracy instead of an independent, as you say, tribunal within the Department of Interior. And then I guess if you ever get through all of that, in theory, you can file under the Administrative Procedures Act in federal district court. Because we're talking about individuals, who may not have access to legal counsel, right? These are very rare. And so the decisions of the federal courts on this is very rare as well. But I think it is accurate to say that what rules the BIA is applying, or tribal contractors operating under 638 contracts, let's be clear, it's not just the BIA, it's also tribes through their government, though they're being funded by a 638 contract. If you ask, hey, what show me the written policies that you are following to make this decision about my CDIB, I'd be very interested to see what they will produce.
Yeah.
Because there are no published regulations, right?
Yeah.
Maybe there's compilations of mysterious guidance memos, as we've talked about, but, why do you apply the paternity rule? Well, here's this memo from 1963 that says to do that, so that's why we're doing it, right?
So I also want to deposit some questions to you and get your opinion on them. So because reading this article brought a lot of scenarios to my mind, and this was, I think, last year, in the middle of last year, that I read it and was working on this, and it's become even more scary now because of the administration we have. What if you had a president who wanted to go in and find places that he could cut spending, and he went to the Department of the Secretary of the Interior, and he said, I want you to go to the BIA, and I want you guys to conduct an en masse review of these tribes' CDIBs, all of them, like all of the Creek CDIBs. I want them all reviewed, and if we can bump their blood quantum down or deny them a CDIB, I want you to do it. Is that possible? Is that feasible? Would there be anything to stop that type of an action, since we don't know the rules?
I mean, there are scenarios like Mr. Underwood, and I'm sure there's anecdotal evidence of different tribal 638 or BIA programs for reasons that may or may not be stated, for reasons that may or may not be in good faith, have gone through. Because, even the BIA will admit in their draft rules from 2000 that there are potential inaccuracies in the base rolls and federal, I looked it up today, the criteria from Mvskoke, and best as I can tell, and you can correct me, you look at the Dawes rules, and there's a lot of litigation in the early 20th century, particularly when Congress sort of released people from restrictions based upon blood quantum, where people said, wait a minute, that's wrong. That blood quantum on there is incorrect. Well, Congress anticipated this problem because it says in the statute, the blood quantum listed on the Dawes roll is conclusive, right? Whether it's accurate or not. And then you go generation to generation to generation to generation. Who made changes? I've seen the Navajo rolls penciled in, crossed out,
right?
And these are the official base rolls that people are using, right, for enrollment purposes. And so could it be, in the absence of regulations or statutory controls, if you will, that a particular president might, for some reason, decide to do that? I'm not sure what's going to stop that person from doing it, other than, the usual litigation, which we may see. But, what is the legal stopgap on this? I mean, right now, it's on an individual basis through the bureaucracy of the BIA, right? I mean,
and you can
go ahead.
Well, I was going to say, you can make an argument that because this is a bureaucratic regulation and it was not codified by Congress, that these regulations themselves are some form of executive action, right? It's not something that Congress said to do, other than they said, if you want to allocate these monies, you need to have some type of determination of whether someone's a Native American. So if you filed a legal challenge, you would be challenging it basically under federal rules of how things are supposed to be proceeded in other instances, because we don't have them for the CDIB. And that's going to be a difficult, I would imagine that would go to the Supreme Court, because I don't know how many of those cases have ever happened, because most of these challenges would have been previously addressed by IBIA, right, or an equivalent, like
not anymore when you've stripped the IBIA of jurisdiction.
Right, right.
Right. And this is why as I was saying, you don't see many published cases, right? Because courts don't have to publish all their cases, so there may be some obscure unpublished cases floating around, but they're not precedent, which means it's hard to find them even if you're an attorney with a Westlaw or Lexis account. Some unpublished decisions Lexis or Westlaw includes or not. If you have a Pacer account, which is of course a fee account, maybe you can track some of these things down. Professor Fletcher with Turtle Talk does a very good job of finding these kind of obscure district court cases. But I mean, the fact that collectively we have not been able to find very many actual cases of individuals other than Underwood where this has happened, it's happened, but they may not have the wherewithal, the resources to go through this elaborate process and then get to district court, then circuit court, much less the Supreme Court. But if a hypothetical president did something like that, the tribes definitely would get involved, and they of course have, some tribes, significant legal resources. So I agree with you. If that happened as a tribal nation matter, there would definitely be litigation. Now, how you sue the president, if you want to do that, I suppose you would enjoin the Secretary of Interior from directing BIA to do that. What the legal arguments would be why somehow the Secretary of Interior is not allowed to revise federal documents, right? It presents an interesting question because, as we discussed, and you know better than I, most, if not all the tribes, their enrollment documents ultimately lead to a federal census roll or a base roll or a DAWS roll. So each tribe, separate and apart from CDIBs, are relying on these federal rolls. If then the federal government changes information on those federal rolls, presents an interesting dilemma for tribes, not just for CDIBs, federal document, but now tribal enrollment and how you deal with all of that. Because this is so, as I say in the paper, intertwined and entangled, right? And if you read that tribal enrollment book from 1984, you will see that it fully encourages tribes to utilize federal base rolls as their enrollment rolls.
Yeah.
So now how do you disentangle that if then the federal base rolls are manipulated in some way that tribes don't like? I don't know.
Yeah, and you could even, if I was playing devil's advocate or if I was on that side of the argument, I would say, hey, listen, we're just getting rid of your CDIBs. It's not going to affect, you guys can do your enrollment however you want to enroll it. Right. We just don't want to pay for your health care anymore. We don't want to pay for your housing anymore. We want to get those savings. We don't care about treaty rights. I guess you would ultimately be trying to make a treaty rights argument at the Supreme Court down the road. We have a lot of questions that are in the chat. And I've gotten to where I think we're all caught up on the history and what a CDIB is. I'm going to try to go through these questions really quickly. Mvskoke History is asking, can we discuss that blood quantum is based on scientific racism of early biological anthropologists that would be instituted into the U.S. Indian policy? I think absolutely you can discuss that, and you guys are discussing it. So I'm going to keep going. How does blood quantum as a certificate of identity conflict with tribal identity as a special political status guaranteed through treaties? That's kind of what we were just speaking about. So I think we've kind of covered that. Blood quantum, that's a statement. When the Creek Freedmen finally get back on the roll, does blood quantum go away? I don't know about that. I don't think so the blood quantum situation is, I would need you to hone down what you mean by go away. Because like we were just discussing, a lot of tribes tie their membership back to some type of federal census, and that's where that blood quantum's getting introduced. I don't know if you can get it to go away in any sense. Now, the federal government may be able to say that. The federal government, maybe Congress, they might be able to pass something and have the president sign it that says we no longer recognize the racist thing of blood quantum or something, and who knows how that would affect those roles. Let me keep going down the line here. I don't know if I mentioned...
If I could just comment on that point, it's
sure, go for it.
So, like the Cherokee Nation, of course, as accepted freedmen, right, who, according to the Dawes rules, right, do not have blood quantum, setting that aside. So you have a situation where you have tribal members with no Indian blood, right? So Cherokee Nation, even Cherokee by blood, I suppose they have some blood because it's Cherokee by blood, doesn't have a threshold cutoff. At least the Cherokee Nation of Oklahoma. Now, Kituwa Bend's different, of course, in Eastern Cherokee, but the Cherokee Nation of Oklahoma. But Cherokees get CDIBs, right? And so yes, you can be a Cherokee citizen who's a member, not based on blood quantum, but lineal descent, but then also has a CDIB, Baby Veronica. In the Baby Veronica case of the U.S. Supreme Court, everybody knew in the entire nation, in the world, what her blood quantum was, because the attorneys knew it. And the attorneys who were attacking the ability of the father to assert the Indian Child Welfare Act before the Supreme Court kept going on. 3,256, 3,256. Well, she's a Cherokee citizen. Doesn't matter what her blood quantum is, right? But they knew it. Why? Probably because she had a CDIB. And that became an issue in the case. And Alito picks up on that and says, oh my goodness, how could it possibly be that a child of 3,256 blood is Indian for purposes of ICWA, blah, blah, blah. Right. But also, I would say, other than the CDIB, there's in the citations, in the footnotes, there's a number of different articles, include ones that I've written about the history of blood quantum, separate and apart from the history of CDIBs, particularly the first comment. I would say look at those articles, particularly one I did for the South Dakota Law Review, which talks about where blood quantum came from. And I can have some agreement with the assessment of this individual as to the origins of blood quantum.
Okay, we got one more question I wanted to get to here. Mvskoke History is asking, do all federally recognized tribes have or are required to have CDIBs? That I don't know. I don't know every one of all the federally recognized tribes if they require CDIBs, but you do have to have a CDIB if you want to get any type of federal assistance of any kind, like your IHS or your HUD funding and various other things. That's kind of like the genesis of it, is Congress was passing laws saying we want to help the Native Americans because they are in a bad situation. They have higher rates of poverty and disease and etc. So we want to allocate some funds to them, the individuals, so that they can try to come out of poverty, etc. But they didn't. They never established any way to determine whether someone is a Native American, and they, in those things that those laws they passed, they just told the BIA, you guys need to figure out some way to do this, okay? And then the BIA had to figure it out. So,
just on
sure.
That, do tribes have to use blood quantum? No, they don't. They can decide whatever criteria they want to be a citizen of that tribal nation. But as you correctly say, for federal purposes, for federal programs of certain types, getting educational loans, whatever, marine mammal, you have to have a threshold blood quantum. And that has created this kind of entanglement between tribal nations, which could abandon blood quantum if they wanted to. Very few have, and that's a policy question for each tribal nation, as I say. But unless Congress changes those underlying statutes and regulations, no matter what tribes do, there's still going to be the need to prove blood quantum for certain purposes. And therefore, are CDIBs going to go away? Probably not, right? So do tribes need to have CDIBs? An individual could choose, I suppose, not to get a CDIB and just rely on membership in their tribal nation. Maybe we'll just get a tribal enrollment card, right? Unlike tribes like Navajo Nation, where the enrollment certificate is also your CDIB, right? If you disentangle the two, nothing requires to get a CDIB. It's not like they mandate and require, here's your CDIB, you have to have this. You apply for it, and you seek it out, and you get it voluntarily, right? So that's an important thing to distinguish, in that, tribal enrollment is voluntary. You have to apply to be a member of a tribe. Some tribes require you to file a separate application, the federal application, to get a CDIB. Maybe your tribe doesn't have a 638 contract, you have to go to the BIA. So you get your enrollment document from your tribe, you get a CDIB from the BIA. A lot of tribes, it's the same place because of 638. They're actually also doing the federal job of issuing CDIBs. But nothing requires you to get a CDIB if you don't want one.
All right. I think you covered all the bases there. I do not see any other questions in there. If I missed your questions, you guys, I apologize. I tried to get them all. And, we're kind of flying blind here anyway. That's kind of the main thrust of why I wanted to do this Lawyered Up about CDIBs, is because, we don't really know what the rules are for sure, and that's not good when you're dealing with the federal government. I wanted to let you guys know next week we have scheduled a live wire on the 26th. It's going to be about the Loksi Shali, the Chickasaw, I think it's an opera, Shell Shakers, that's making its East Coast premiere, and Jared Tate and Dr. Kirsten Kunkel are going to be on the program again. You guys want to tune in for that. And I am probably going to be doing another Lawyered Up next week, because in addition to the oral arguments that happened today, the Creek Nation filed another lawsuit against the county of Tulsa and the DA there for continuing to prosecute crimes against Native Americans on the reservation, similar to the other Mvskoke Creek Nation versus City of Tulsa. So I
need you to pick up one.
You're all right. And so with that being said, you guys, keep an eye out for that next week. And Mr. Spruhan, thank you so much for joining me today. You've been a great guest.
Thank you.
All right. And we will see you guys later. Take it easy. Mado Hadum Chihichat, please.